So for the pretrial motion, both sides will have 4 minutes to present their arguments. The defense will begin first. I will interrupt to ask clarifying questions. Time spent answering my questions is not included in the 4-minute time limit. At the conclusion of your arguments, each side will be offered 2 minutes of rebuttal time. Remember that the rebuttal time is to be used to counter your opponent's arguments. It cannot be used to raise new issues. Is counsel for the defense ready to begin?
Yes, Your Honor.
All right. If you would please summarize your arguments.
Yes, Your Honor. May I proceed?
You may.
Your Honor, the defense respectfully requests that the 995 motion be granted and count 2 of criminal threat be dropped. We are here this morning because a friendship that once was had come to an end. My client Reagan Klein and Sawyer Smith had grown apart, and Sawyer Smith's potential rise to fame caused him to drop my client as a friend. Understandably, Klein was upset, and in an unfortunate lapse of judgment, commented on one of Sawyer Smith's posts, paraphrasing, Your Honor, saying, "You deserve to die." However, there was no probable cause to show that my client's statement can constitute a criminal threat.
Well, wouldn't a reasonable person hearing those words consider that a true threat?
No, Your Honor, because they lack enough specificity to say when, where, or how my client is going to execute their putative threat.
All right, go ahead, continue.
According to California Penal Code 422, for a threat to constitute a criminal threat, it must be unequivocal, unconditional, immediate, and specific. Secondly, it must also have a gravity of purpose and immediacy of execution. And lastly, the person receiving the threat must be in reasonable sustained fear. And Your Honor, all of these elements are absent in our case. My client's statement lacks enough specificity on its surface to constitute it as a criminal threat. We can look to the analogous case of In re George
Didn't
T.
your client say, "I'm coming for you"? Isn't that a specific threat? You deserve to die and I'm coming for you?
No, Your Honor, because they didn't say when, how, or where they're going to execute it. In the case of DC versus RR, it was also ruled that grotesque and exaggerated languages, statements such as burn in hell and pound your head in with an ice pick and rip your heart out, were considered to be specific enough, whereas in our case, my client's statement lacks enough specificity.
All right, go ahead, continue.
In the analogous case of In re George T., the state Supreme Court ruled that the defendant's statements lacked enough specificity. In this case, the defendant was prosecuted because they handed out dark poetry to fellow students, consisting of statements such as, "For I can be the next kid to bring guns to kill students at school."
But isn't this distinguishable from George T? He's writing poems in school, and your client is making threats on the internet to a specific person. So doesn't George T hold something that's different than what's the fact pattern in this case?
Your Honor, the ruling in George T. was ruled if it was specific enough. They talked about the specificity in that case. In that case, the defendant still wanted harm to come to the victims that they wanted to. Therefore, they discussed the fact that it was a true threat or not.
All right, go ahead. You can continue.
In this case, the defendant was prosecuted because they handed out dark poetry, with statements consisting of, "Probably I will be the next high school killer." And Your Honor, those comments are more specific than the comment made by my client. And because those comments were considered constitutionally protected free speech, then my client's statement should also fall under that ruling. Secondly, there must also be a gravity of purpose and immediacy of execution. And there's no evidence to show that my client wanted to execute their putative threat.
What about the whole swatting incident where he calls out the SWAT team to go to the victim's house?
Your Honor,
Isn't that a gravity of execution or immediate act towards executing the threat?
Your Honor, the swatting incident is a completely separate incident from the putative threat. There's nothing in the putative threat pointing directly to swatting, and therefore there's nothing in the swatting incident pointing back to the putative threat.
All right, go ahead.
We can look to the analogous case of In re Ricky T., where in this case it was ruled because there was no accompanying physical force, it showed no gravity of purpose. In this case, a student was accidentally hit in the face with a door by a teacher. In response, the student said, "I'm going to kick your blank, I'm going to get you." and the court ruled that these statements alone, though rude, were not enough to hold a gravity of purpose.
But that teacher was not in fear. Wasn't that the holding in that case, that since there was no sustained fear, the threat didn't matter? In this case, we have victims saying that he was fearful because of those threats that were made.
Your Honor, it's the defense's position that Sawyer Smith was not in fear. And Your Honor, even if he was in fear, it was unreasonable under the circumstances.
All right, thank you. You can go ahead and continue.
And the court ruled in the case of In re Ricky T that because there was no accompanying physical force, it showed no gravity of purpose. In our case, there was no accompanying physical force, and nothing to give it a gravity of purpose. Therefore, my client's statement cannot constitute a criminal threat. The last critical rule, Your Honor, is that the person receiving the threat must be in reasonable sustained fear, and that's not the case with Sawyer Smith. In the case of In re Ricky T, it was ruled that the teacher wasn't in fear because they didn't report their fear to the police. Similarly, Sawyer Smith didn't report his fear. He continued to stream a movie as if it was any other day of the week. And additionally, he replied to my client's comment by saying, LOL, as if you're done now, bye.
But what about the Chandler case, which says that even though the person doesn't express fear, it doesn't mean they can't be in sustained fear?
Yes, Your Honor, but Sawyer Smith could have still easily reported his fear to the police without showing it to his followers.
All right, you can go ahead.
In the case of In re Ricky T, it was ruled that the teacher wasn't in fear because he didn't report their fear to the police, similarly to the case with Sawyer Smith. But Your Honor, even if Sawyer Smith was in fear, it was completely unreasonable under the circumstances. In the case of People v. Jackson, the Court of Appeals ruled that the landlord's fear was unreasonable under the circumstances. And in that case, Your Honor, the landlord had asked the defendant to leave, and the defendant responded by getting a weapon. In that case, the landlords then watched the defendant on the porch, unbeknown of what they were going to do next, showing that their fear was unreasonable under the circumstances. The court ruled that actual fear is not enough if unreasonable under the circumstances, and there's nothing to show that Sawyer Smith's fear was reasonable under any circumstances. In conclusion, Your Honor, the defense respectfully requests that the 995 motion be granted. Thank you.
Thank you, counsel. Prosecution, your argument?
Yes, Your Honor. May I proceed, Your Honor?
Yes.
May I ask the court, the people request that Your Honor deny the defense's 995 motion to dismiss count 2 criminal threats because the defendant's threat was unequivocal, evidenced by the surrounding circumstances of the threat, and because Ms. Sawyer Smith was indeed in sustained fear. The people, the defense, would like to argue that Reagan Klein's comment was not unequivocal, for there were individual sentences that had no clear action for Smith to be fearful of, that there was no immediacy. However, we must look at the cohesive piece, from beginning to end, as Ms. Sawyer Smith would have read that very day. And in examining the entirety of the threat, we can see that there is a clear motive.
Well, counsel, we see threats like this on the internet all the time, every day. Every day on Twitter, you hear people threatening people. Are we going to prosecute every person who makes a threat like this just because they post it online?
Yes, Your Honor, we cannot prosecute every single person. However, in this case, we must look at the surrounding circumstances as well, in addition to the contents of the threat. And the surrounding circumstances show that there was sufficient history of animosity.
What about the defense argument that this threat is not specific enough? There's no unequivocal threat, it's just kind of a generic threat. How do you respond to that?
Yes, Your Honor. The threat may lack some factors of element 4 that CalCrim 1300 requires, and the case of George T. does state that the primary factors in considering a true threat is the contents of the threat. However, the case of George T. also states that if the contents are vague, we must weigh more heavily the surrounding circumstances.
All right, so what are those surrounding circumstances that make up for the lack of specificity in the threat?
Yes, Your Honor. In this case, I thought there are 2. 1, the history of animosity, and 2, conduct suggesting to kill.
All right, you go ahead and continue with your argument.
Now, we must read the statement in its entirety. You deserve to die. I'm going to get you for this. I hate you. When you're dead, no one will even miss you, you monstrous slime of a person. When you're dead, no one will even miss you. You think you could stick me with a $34,000 lawsuit and just get away with it? Watch your back, Sawyer. I'm coming for you. The defendant clearly addressed a motive, the $34,000 lawsuit, to Sawyer Smith, and directly addressed this to Sawyer Smith. Now, once again, we must not only consider the contents of the threat, but we must consider the circumstances surrounding the case at bar. And there was, once again, a history of animosity and conduct suggesting to kill. Now, Ms. Smith had dropped Reagan Klein as a friend, and Ms. Reagan Klein, in return, catfished and humiliated Sawyer Smith. Sawyer Smith, in turn, revealed Reagan's deepest, darkest secret, causing her to get fired and threatened to be sued with a $34,000 lawsuit. In addition to the lawsuit and having recently gotten from her job, she also had college debt that she had to pay. And under the stress of all this, the defendant threatened Sawyer Smith.
But doesn't there need to be some sustained fear, and where is it in this case?
Yes, Your Honor. Elements 5 and 6 of the CalCrim does state that Sawyer Smith must be in sustained and reasonable fear. Now, Sawyer Smith must have been in sustained fear, not because she wrote the comments LOL, but as the case of Chandler says, victims who have been put in a state of sustained fear can indicate that they have lack of fear because they don't want to show that they have been intimidated by the defendant or by the threat.
All right, thank you. You can go ahead with your argument.
Yes, Your Honor. So Ms. Sawyer Smith was indeed in sustained and reasonable fear. Ms. Sawyer Smith, though she did write the comments LOL as if, she did not mean it. And in her witness statement, she writes, "I was trying to look tough for my followers." So not only did she want to not look intimidated in front of the defendant, she wanted to look tough for her followers. And because she had a reputation to uphold, she believed she could not show that fear. And also, Your Honor, subsequent to the threat, Smith had gotten swatted. And immediately after she had been swatted and sustained considerable damage while she was in the ambulance on the way to the hospital, Smith had immediately thought of the defendant and the threat. She notified Officer Keegan Lopez of who she thought might be the sender of the text tip, and she had shown Ms. Officer Keegan Lopez the threat that Reagan had sent earlier that day. There is a conduct suggesting to kill. Reagan Klein, who had sworn to get revenge on Sawyer Smith by sending the false tip, was able to carry out the threat.
What about the Jackson case? In that case, the threat was, "I'm going to blow your head off with an AK-47. The court said that wasn't enough. This doesn't rise to that level.
Yes, Your Honor. From People v. Jackson and the case at bar, there are two distinctions. One, yes, there was a specific language involved in the case of Jackson. However, there were absolutely no surrounding circumstances involving the defendant and the landlords, the two parties that were involved in the threats. And also, the landlords were considered to have unreasonable fear because the defendant was in a clear line of sight without the weapon that the defendant mentioned he would shoot them with. So the question we must not ask ourselves is not whether or not they had a lack of reasonable fear, but whether they had unreasonable fear. And in this case, there are no evidence to show that Sawyer Smith was in a state of unreasonable fear.
All right, thank you. Go ahead, continue.
So Ms. Sawyer Smith, for the whole day, had been thinking of the defendant and her threat, and when Ms. Reagan Klein had finally executed the threat, Ms. Sawyer Smith had thought immediately of the defendant, showing that she was in sustained fear. Officer Keegan Lopez, who also saw the threat, deemed the comment threatening, also showing that the threat was reasonable and her fear was reasonable. And finally, Your Honor, the defendant intended to communicate this threat to Sawyer Smith. This is shown in the case of DC versus RR, where the message and its transmission, the whole process of typing it out and sending it over electronic communication, showed clear deliberation. For these reasons, because the threat itself was unequivocal, evidenced by the surrounding circumstances of the day, and because Ms. Sawyer Smith was in sustained fear, and because the defendant intended to threaten Sawyer Smith, that the people request that Your Honor deny the defense's 995 motion.
Thank you, counsel.
Thank you.
Defense, you've got 2 minutes for rebuttal.
Yes, Your Honor. May I proceed?
Yes.
Your Honor, opposing counsel has brought up the fact that my client had a motive. But, Your Honor, that is not a relevant ruling factor according to California Penal Code 422. And additionally, my client's statement was an off-the-cuff statement. because they made it in response to Sawyer Smith's gloating post. They were typing and they weren't looking back. Like in the case of In re George T., where in this case, the student was hit in the face with the door by the teacher and said, "I'm going to get you." In our case, Reagan Klein was hit with a $44,000 lawsuit and said, "I'm going to get you," in an off-the-cuff remark. Opposing counsel has also brought up the fact of the surrounding circumstances. And Your Honor, the court only looks at these when the statement is vague, which the defense agrees. And those three are no accompanying threatening gestures, which are not present in our case, no immediate prospect of execution, which is not present in our case either because the swatting incident is a completely separate thing from my client's putative threat, and lastly, no history of animosity. And Your Honor, there is no history of animosity in our case. Sawyer Smith had decided to drop my client as a friend. My client, in response, decided to start a catfishing account to show Sawyer Smith the light. But Your Honor, this doesn't count as animosity because Sawyer Smith didn't know it was my client. The only animosity that begun was when Sawyer Smith decided to get my client fired from her job at Hennessy's.
30 seconds.
And Your Honor, the actions following that happened over a 24-hour period. That does not count as a history of animosity. Also touching on the fact of sustained fear. Your Honor, this must be reasonable under the circumstances according to the ruling of People v. Jackson. And Your Honor, if we look at Sawyer Smith's actions, they are not reasonable under the circumstances. Therefore, the defense respectfully requests that the 995 motion be granted and count 2 of criminal threat be dropped. Thank you.
Thank you, counsel. Prosecution, you have 2 minutes for rebuttal.
Yes, Your Honor. May I proceed?
Yes.
While the CalCrim does state that motive is not a factor in the case, I have brought it up to show that there was indeed a history of animosity, a clear and specific motive that was directly addressed to Sawyer Smith. And on top of that, the defendant had said, "Watch your back, Sawyer," directly addressing the victim in the case at hand. Now, the defense has also brought up the case of George T., saying that Reagan Klein only responded in anger. However, DC versus RR says the exact opposite, that the message and its transmission, the fact that it had been typed out without any grammatical errors, and that the transmission of it electronically shows deliberation. And also, if it was indeed in a haze, in a fit of anger that Reagan Klein had sent the threats, why had she not deleted it? She had kept that post for the duration of the day until Smith had gotten swatted. Now, as for the swatting incident, we can see from People versus Martinez that not only can a vague threat be considered a true threat, that the second count, arson in that case, was a supporting and indicating factor to prove count 1, criminal threat. And that case is directly analogous to the case at hand, for though the threat was vague, the conduct suggesting to kill proved that the circumstances were evidence enough to put Ms. Sawyer Smith in fear. And for these reasons, the prosecution would like to request that you deny the defense's motion. Thank you.
Thank you, counsel. Before I rule on the motion, students may confer with their attorney or teacher coach regarding any trial irregularities. Please note that this time should be used to raise substantial rule violations only and should not be used to argue additional points of law or rebut opponents' arguments. Arguing for hyper-technical interpretations of the rules, especially when designed to embarrass others or to gain an unfair advantage, is prohibited. You have 30 seconds to confer. Please do so now.
The prosecution has none, Your Honor.
All right. Would either side like to note any trial irregularities?
The defense has none, Your Honor.
All right. So, first of all, let me congratulate both of you on your arguments. Both did an excellent job of making your points. The First Amendment does guarantee freedom of speech. However, there are limits on our freedom of speech, and the penal code section that's been charged in this case is one of those limits. The court does find that the threats were sufficiently unequivocal, unconditional, and immediate to indicate that there was a true threat, and there is evidence that the victim in this case was in sustained fear. And for those reasons, the court is going to deny the defense 995 motion at this time. Thank you both.
Your Honor, before we proceed, may we